Deferred action enjoys a long history. It is one type of prosecutorial discretion in immigration law. It provides a temporary reprieve or protection to an individual in humanitarian or other compelling circumstances.
Deferred action has been a lifesaver for so many individuals, including a few of my clients. I have countless stories from other attorneys that talk about individuals who have been getting cancer treatment, and this has saved their life as they've been able to stay here and get treatment where they could not back home.
Today's hearing was around so-called medical deferred action, or those cases where people who are in a clinical trial, facing a life-threatening disease, or taking care of U.S. citizens who have a serious medical condition have had deferred action. This hearing was a response to the change in policy by U.S. Citizenship and Immigration Services to terminate the policy. There was outcry and outrage from House Democrats, the American medical community, and the American public at large as to why the agency would choose to target the most vulnerable among us for deportation.
My client, for example, came on a visitor visa and after open heart surgery and severe complications had to stay in the United States for much longer than expected. And using letters from her physicians and her care providers, she applied requesting additional time to stay in the United States to recover.
I was hoping to get more information from the two witnesses representing the government today. The public is hungry for more information about what happened to deferred action at USCIS and what we can expect in the future. And unfortunately, the government officials simply did not deliver today. By contrast, I was so moved by the first panel and honored to be joined by not just the medical and legal experts, but the two children who were affected by deferred action. They spoke eloquently and from the heart, and I think their stories really came through today. Another part of the testimony and the hearing focused on which agency should administer deferred action moving forward. And ICE believes that it, as a prosecuting agency, or rather the minority witness, believed that ICE should be the one who handles this. But there are a lot of reasons why this is concerning.
Individuals who are seeking deferred action are quite vulnerable for a variety of different reasons, be it because of health issues, a death in the family, and based on this emotional burden, it would be really difficult to imagine someone applying to ICE for deferred action. Besides the human impact on someone and the stress that this would cause, the process of applying for deferred action through ICE essentially involves going through an entire removal proceeding with an immigration judge, trial attorneys, and getting a deportation or removal order from a judge, and then requesting ICE to say, please don't remove me, don't carry out this deportation order, and allow me to stay in the United States for deferred action. The burden of that is extreme and unbearable for individuals who are quite vulnerable.
USCIS should reinstate the whole humanitarian deferred action policy. They are the appropriate agency to administer deferred action. They have the expertise. They process applications for vulnerable populations on a regular basis, and their culture and outlook historically has been services-oriented and acted with more compassion than we've seen coming out of ICE.
Sadly, we've seen a tremendous amount of change come out of this administration in the last 2 years when it comes to immigration policy. There have been really horrific, heart-wrenching stories, and this is just one of them. We need to hold CIS accountable, and AILA will be looking and seeking for examples of individuals that are going to be impacted by this change.